Welcome to Term Talk, the video podcast from the Federal Judicial Center that discusses which Supreme Court cases will likely impact lower courts the most during the previous term. I'm Hamid Khan, Judicial Education Attorney at the Federal Judicial Center. In the next 15 minutes, we will discuss United States versus Rahimi and Garland versus Cargill. Joining us today are Erwin Chemerinsky, Dean, and Jesse H. Chopra, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Tara Grove, Vinson and Elkins Chair in Law at the University of Texas Law School. Thank you both for being here today.
It's a pleasure.
Thanks so much.
Erwin, in United States versus Rahimi, the Supreme Court provided additional guidance. Can you provide us with the facts of the case and explain how it fits in the history of the Second Amendment jurisprudence, especially those that have occurred over the past decade?
From 1791, when the Second Amendment was ratified, until 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. In the handful of Supreme Court cases about the Second Amendment, it always said it means what it says. It's the right to have guns for purpose of militia service. This changed in 2008 in District of Columbia versus Heller. The Supreme Court there struck down a DC ordinance that prohibited ownership or possession of handguns. The court said there's a Second Amendment right to have a handgun in the home for the sake of security. But the court didn't prescribe a test or a level of scrutiny for the Second Amendment. 2 years later in McDonald versus City of Chicago, the Supreme Court simply said that the Second Amendment is incorporated. It applies to state and local governments. It wasn't until 2022 in New York State Rifle Association versus Bruin that the court prescribed a test for the Second Amendment. That was a case that involved a New York law that was over a century old that said you can't have a gun in public without a permit. To get a permit, someone would need to show cause. The Supreme Court declared that unconstitutional. Justice Thomas, writing for the majority, then spoke to the test to be used. The court rejected the traditional levels of scrutiny. The court said there isn't to be any balancing when it comes to the Second Amendment. Justice Thomas said the Second Amendment is, quote, an unqualified right. So the only regulation to be allowed are those that are supported by history and tradition. Well, in the 2+ years since Bruin, there's been hundreds of cases in the lower federal courts and state courts challenging every imaginable kind of gun regulation. The first case to come to the Supreme Court since Bruin about the Second Amendment is what we're talking about now, United States versus Rahimi. It involves a federal law that makes it a federal crime for a person under restraining order in a domestic violence case from having a gun. Zaki Rahimi abused his girlfriend. When someone came to help her, he fired a gun. She went to court and got a restraining order against Rahimi for a 2-year period, keeping him from in contact with her or her family. The judge in issuing the restraining order told Rahimi that he wasn't allowed to have a gun for the time of the restraining order because of the federal statute. Rahimi was then a suspect in a number of other gun crimes. Police got a search warrant for his home. They found a large number of guns. Ironically, with the guns, they found a copy of the judge's restraining order that he wasn't allowed to have guns. He got prosecuted in federal court for violating the federal statute. He challenged it. The district court upheld the statute. Rahimi entered a conditional guilty plea. He went to the Fifth Circuit. The Fifth Circuit struck down the law. The Fifth Circuit said, under the Bruin test, the only regulation of guns are allowed are those that historically existed. In 1791, there weren't laws that kept people under restraining orders in domestic violence cases from having guns. So the Fifth Circuit said, this is unconstitutional. The Supreme Court, in an 8-1 decision, reversed. Chief Justice Roberts, writing for the court, ultimately said there were sufficiently similar analogs in 1791 and at that time period to allow this law.
Tara, can you please take us through the Supreme Court's analysis?
As Erwin was just saying, the Supreme Court upheld the law. Now, it was an interesting division in the court. It was 8-1. The dissenting opinion by Justice Thomas was written by the same person who had written Bruin and said clearly under Bruin, this statute is invalid, which is also what the Fifth Circuit had said. The Fifth Circuit said, look, domestic violence itself was not deemed illegal in this 18th or 19th century. And so whether you're looking at 1789 or the 1860s, how could it possibly be legal now? So under a test that looks to a historical analog, the Fifth Circuit had said, and Justice Thomas said in dissent in Rahimi, there can't possibly be regulation today of domestic violence. And that actually follows pretty reasonably from the Bruin analysis. But what the court majority said, and 8 justices agreed on that, is that both the Fifth Circuit and the dissenting opinion were not treating the historical analysis correctly. In fact, the proper historical analog doesn't have to be an exact copy. It can be something that's a little bit broader and different. And what the court found was that if you look back in history, it's true there were not domestic violence orders against people who had committed domestic violence, but there were regulations of people who posed a credible threat to the physical safety of others. And they looked to, for example, laws that required people to post a surety, so some money, if they posed a credible threat to others. And using this somewhat more generous historical test, Chief Justice Roberts' opinion found that the law at issue in Rahimi was valid. Now, there were a lot of opinions in Rahimi, a lot of different justices weighing in. Justice Sotomayor, joined by Justice Kagan, said, well, we agree with the majority here, but this may actually spell some problems with the historical analysis that Bruin set up. Justice Jackson said something very similar. Justice Jackson said, look, this decision is correct, but the Bruin test requiring courts to kind of try to find some kind of historical analog creates a real mess for the lower courts. And this is a mess of our own making, a mess that we should clean up, and a mess that we did not clean up today. And some of the other justices weighing in and saying, we're still interested in doing some kind of historical analysis. Justice Gorsuch emphasizing that everybody is looking to history, believing that history provides some clarity here. And Justice Barrett continuing to say the history close to the founding, either 1789, 1791, or the 1860s is the critical history and not stuff that happens far beyond that. So that was the basic analysis of the court. It basically changed the level of generality by which one looks at historical analogs. But I'm going to suggest that that creates even more confusion, or will create even more confusion among the lower courts.
Erwin has already alluded, Justice Thomas wrote a 32-page dissent, nearly twice as long as the majority's opinion. How did he analyze the case?
It's important to remember that Justice Thomas wrote the majority opinion in Bruin. Justice Thomas says that the approach under Bruin is you have to look at history at a very specific level of abstraction. Did this kind of law exist in 1791? Justice Thomas says there weren't such laws in 1791, therefore this law should be declared unconstitutional.
Erwin, what are the takeaways for the lower courts?
I think the most important thing for the lower court is that Chief Justice Roberts' majority opinion continues the historical analysis from Bruin. Nowhere in Chief Justice Roberts' majority opinion does he talk about how this law is desirable because it saves lives, especially many women's lives. His approach is to look for whether there's a sufficiently similar historical analog to permit this law. I think that this bodes well for the constitutionality of laws that prohibit ex-felons from being in possession of firearms, because there in those cases had been an adjudication that establishes dangerousness. I think it's much harder to find guidance from this case about laws that prohibit particularly dangerous type of weapons, or laws that regulate where people can have guns in public, because the court really doesn't discuss anything like it in Rahimi.
Tara, what takeaways would you offer?
So I agree with all of that. And I also anticipate a real cacophony of decisions among the lower courts. Lower court judges already disagreed on many of these issues. And right now they have 2 different precedents. Bruin seemingly requiring a very strict historical analysis, and Rahimi saying, no, it doesn't have to be that strict. And I anticipate different lower courts will do different things with respect to the same federal statute, and certainly with respect to similar statutes across different states.
Well, let's move on to Garland versus Cargill. This opinion is from the High Court, applies a strict reading to a federal law defining and restricting machine guns. Tara, what are the facts of this case?
This involved a statute, as you said, that defines what is a machine gun. And a machine gun is, quote, any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger, end quote. So what does that mean, and what does it apply to? So it's very clear that it applies to an automatic weapon where somebody fires and the gun keeps going and going and going. What's less clear is what else it applies to. So there are also semi-automatic weapons where someone fires and they don't keep going and going and going, but there's a way to modify a semi-automatic weapon by using what's called a bump stock that makes it function a lot like an automatic weapon. So someone installs a bump stock, and then if someone holds their hand to the trigger, the weapon will keep firing, much like an automatic weapon. So the main difference being with an automatic weapon, you just pull the trigger once. With a semi-automatic, with a bump stock, you hold on to the trigger and the gun keeps firing. Okay, why is all this important? Well, the question is, can the federal government under this statute ban a semi-automatic weapon with a bump stock? For a very long time, the Bureau of Alcohol, Tobacco, and Firearms said, no, we can't. That's not actually an automatic weapon, it's different. But after the Las Vegas shooting, which was just a terrible massacre of individuals, the ATF reconsidered. In the Las Vegas shooting that I suspect many people are aware of, the shooter did use a semi-automatic weapon with a bump stock, killing lots of people, injuring many others. And after this, the ATF reconsidered and said, these are functionally very, very similar. And so we think that under this statutory language, a semi-automatic weapon with a bump stock qualifies as a machine gun and can and should be banned. So this was then litigated. So the person at issue, Mr. Cargill, had a semi-automatic weapon with a bump stock that he surrendered and then proceeded to challenge the ATF's regulation banning these weapons. Now, one of the things that's important to note about this case that I think you were referencing earlier, this is not a Second Amendment case. This is not a case about gun rights. It's a case about what Congress did actually prohibit, and to what extent the ATF was right that Congress prohibited the use of semi-automatic weapons and bump stocks. So in this case, the Fifth Circuit found that the ATF could not ban semi-automatic weapons with bump stocks, and the Supreme Court upheld that as a matter of statutory interpretation.
Erwin, how did they analyze the case?
Justice Thomas focused very much on the language of the federal statute, and he also focused on the trigger function. One of the unusual things about his majority opinion is he included diagrams. And he said a machine gun involves one pulling of the trigger. He said a bump stock is different because the bump stock is effectively repeatedly pulling the trigger. He said that doesn't make it a machine gun, and therefore the regulation is invalid.
Erwin, what did Justice Alito's concurrence add to the opinion?
Justice Alito's concurrence said that we have to follow the text. Tragedy doesn't justify a change in the law. He also emphasized that the ATF for a long time denied that it had the authority to prohibit bump stocks, and therefore he was skeptical that they could change the regulation and their interpretation of the statute. But he also said, if Congress doesn't like this, Congress can amend the statute to prohibit bump stocks.
And Tara, how did the dissent analyze this case?
So the dissenting opinion said that the majority completely misunderstood the statutory language. The dissenting opinion, like the majority opinion, focused on the text of the statute, but said that Justice Thomas's opinion had completely misread it. So the dissenting opinion was written by Justice Sotomayor, joined by Justices Kagan and Jackson. And what the dissent pointed out is the statute itself talks about a single function of the trigger. And they said to an ordinary person, that means when you hold the trigger and, the actual finger touching the trigger and not what's going on inside the gun. And so they say that Justice Thomas's majority opinion took an extraordinarily odd approach to statutory interpretation by focusing on what was going on inside the weapon, when to any reasonable person, ordinary person, they would focus on whether you actually have touched the trigger. And it is true, as I said earlier, that in order to make the semi-automatic weapon with a bump stock work like a machine gun, you just touch the trigger once, and the only trick is you have to hold on to it. Now, one can say there's an interesting question: does that matter in terms under the statute, whether you pull the gun once, pull the trigger once, or have to hold on to it? And so I think there's an interesting question of whether there's an ambiguity in the statute. It could be arguably a very difficult textual analysis. But what's interesting here is neither the majority nor the dissenting opinion really focused on ambiguity. I mentioned this because under a long-standing doctrine of Supreme Court jurisprudence called the Chevron Doctrine, that still existed at the time the Cargill case was decided, if a statute was ambiguous, there would have been good reason to defer to the interpretation of the ATF, even though the ATF had changed its own interpretation, and defer to the interpretation saying that semi-automatics with bump stocks were not allowed. But maybe someone anticipating something else that happened last term, which was the overturning of Chevron, nobody seemed to be talking about Chevron or deference at all.
Erwin, what else should the lower courts know?
I just want to stress this isn't a Second Amendment case. This is a statutory interpretation case. And I think, as Tara said, this reflects a court that believes that the judiciary should not defer to agencies in interpreting ambiguous statutes, that interpreting statutes is for the courts. That's, of course, exactly what the court said in Loper Bright Enterprises versus Raimondo.
Well, thank you both for your insights and helping us understand the implications of these cases.
Thank you.
Thank you.